Hi guys, and welcome back to Contract B. This video is the video for topic 11, and topic 11 is international aspects of contract law. And what you need to bear in mind for today's discussions as we're moving through is that it's really just intended to give you a bit of a bird's eye view of this area of contracting. It really is the stuff of an entirely separate unit. So we're just going to be hitting the high points for today. And then hopefully if you need to go back and have a look at some of this stuff in practice or at some time in the future, you'll know the rough direction in which to head. As a consequence of not being able to really discuss this stuff in detail, you'll see a lot of the readings for this week I've bypassed because in my experience and practice, a lot of that stuff just never comes up. However, I will be briefly discussing the issues that I'm getting you to skip over in the readings. I'll be discussing them in the video briefly today. So we'll be having a look at the Vienna Sales Convention. We'll be having a look at the UNIDWAT principles. We'll be having a look at the EU standardisation effort over there. And also the Incoterms. In my experience, probably the Incoterms come up most often. So I've left those readings in from the text for you. But what I'd really like to focus on is particularly the issue of standard forms, because standard forms are incredibly important in today's e-commerce, and e-commerce is the most natural forum in which to discuss international contracting, because just so much of the international contracting is done on a daily basis by millions of people worldwide via online shopping and such things. So that's the brief map of where we're going today. And yes, the world is shrinking. Always good to start a video off with a cliche, I say. There are a number of different ways, however, particularly for us in contract law, that the world is shrinking. And these are the efforts that are being made as the text describes it. On a number of different levels. So you've got the global level, you've got the regional level, and then you've got the micro kind of private international law level. Looking at the global level, there obviously is no international law, and if you haven't been doing any other subjects that require you to look at international law or treaties or anything like that, the UN is not the global international lawmaker, as some people seem to think. There is no international parliament. And so what is the case with international legal issues? Well, one way of pulling countries together so that they kind of work in the same direction rather than against each other is to engage in a treaty-making process. And the Vienna Sales Convention is probably the main treaty that we need to at least know about in terms of contract law. What happens with the treaty-making process is that the countries will all get together and invariably discuss a particular issue or like contract law for a number of years, and they'll bandy about various different things that they think that should happen. And ultimately, a draft text of a convention will arise at some point, and then the countries will, sign up to that particular convention. Sometimes a convention will require a minimum number of countries to subscribe before it becomes effective. Sometimes the convention will just become effective once the country has subscribed to it and then implemented it in its home legislation. This is what's happened with the Vienna Sales Convention so far as Australia is concerned. We signed in 1988, and it has applied as part of Australian law since the 1st of April Fool's Day, 1989. So in this way, the convention has found its way into Australian law, and it applies automatically to the relevant kinds of contract that are stipulated by the convention. We'll go into those in just a sec. Other than this, on global terms, what can be done to get countries cooperating in the same way rather than conflicting against each other? Well, there has been a model contract law, a huge compendium of legal principle drafted, and it's called the UNIDWA principles, and we'll go into those in just a tick. But they certainly do not apply automatically in Australia as the Vienna Sales Convention does, because the VSC has been applied into local law. Okay, looking at the VSC. The first thing we need to recognise is that, so far as consumers are concerned, it is useless because it applies only to B2B contracts, that is business to business. It also excludes a lot of the really super common transactions that you're likely to come across, like, for example, auctions. They are all kicked out of the purview of the VSC, and so therefore, since we've adopted the principles of the VSC into Australian law, it also excludes the same stuff. The kinds of contract that the VSC does apply to, those principles will apply automatically because they are part of Australian law. However, you can opt out of these kinds of principles. Generally speaking, what does the VSC do? It doesn't really do anything particularly magical. It just really determines the background or the landscape in which contracts are formed. So the main takeaways from the VSC are things like how contracts, how offers will be interpreted, how acceptance will be interpreted, how fundamental breach will be interpreted, and so on. Okay, it really just harmonises for those countries that have signed into the VSC. It harmonises the background stuff and it gives a level of consistency to the way that offers are treated, acceptance is treated, and so forth. The UNIDWA principles were developed by a collection of esteemed commentators on the nature of contract law, judges and academics and so forth. The work really is an outstanding piece of draftsmanship. If you ever get a chance to go and have a look at it, please do. I wasn't going to originally do this, but I thought I'd take you to the table of contents of the UNIDWA principles. You'll see them at unidwa.org. Have a look at these general provisions. Okay, formation and authority of agents. So there's all your provisions on authority. Validity, general provisions, grounds for avoidance. So you can see they go through mistake and remedies for non-performance. All sorts of things. Illegality, interpretation, content and third-party rights. Performance, have a look at that. Non-performance, damages for non-performance. Set off, assignment of rights, whole heap of provisions there. Your limitations, plurality of obligors and obligees. And there you go, a very brief tour of the content of the UNIDWA principles. Quite incredible. But what you can actually do is use this thing as basically a whole restatement of contract law. And you can actually incorporate the UNIDWA principles as the governing law of a contract because they are just that comprehensive. The benefit of this kind of thing is that it's an opt-in, opt-out thing, but if you do opt in and your country happens to be a signatory to the VSC, then this kind of compendium of contract principle can augment whatever gaps there are in treaties like the VSC. So it's an amazing work. However, as Wilmot says down the very bottom bullet point, you can see the evidence is fairly weak that this has had any real impact in Australia. While it could augment gaps in the VSC, not a lot of people tend to rely on it. Again, a very good idea, but like many of the other harmonising attempts, hasn't had a real lot of impact in the way that international contracting is done. Perhaps a shame, because it really is quite a commanding piece of work, but nevertheless, the proof's in the pudding and not many people take it up. In relation to regional attempts, probably the one that the text goes through in the most detail, and the one that you probably wouldn't hurt to know about, is the principles of European contract law, obviously because Europe's an major Australian trading partner. The principles attempt to set this European-wide infrastructure of contract law to consolidate European law. It does cover all contracts, not just commercial contracts. So there's a big difference between this kind of harmonisation attempt and something like, for example, the VSC. However, again, the bottom bullet point there, you can see it hasn't been adopted by the European Parliament as a European contract code. There's been endless discussions about this happening. Watch this space, but as yet, another nice idea, but hasn't happened yet in terms of being enacted as a European law. In terms of the standardisation attempts that have been made around the world, probably the most influential has been the Incoterms, and these are a private compilation of international commercial terms that are used in international sale of goods contracts. There are 11 different contracts that you can choose from, and the FOB, the free on board contract, is a contract that regulates agreements between parties where the seller's liability is intended to stop at the port of export. And the cost insurance freight contract is an arrival contract, so the seller's liability continues until the goods actually arrive at the international destination where they are being shipped to. They're the two that do crop up sometimes in practice. If you want to incorporate the Incoterms into your contract, you just do so by reference. So the text gives you one example. You just put in there CIF brackets Calais brackets Incoterms 2010. That's the most up-to-date version of the Incoterms. And bingo bango, the Incoterms are incorporated into the contract, the international sale of goods contract that you are drafting up. If you want to read more, I suggest that you have a look at the text. They're probably the best example of private international lawyers getting together and trying to harmonise stuff. They do sometimes, as I said, crop up. Okay, so that's a brief cook's tour of chapter 28 for you guys. Probably worthwhile having a look at the Incoterms stuff. But the other stuff from chapter 28 that you probably should look at is the text in relation to private international law and choice of law clauses. Now, these kinds of clauses become important when you are talking about individual transactions. So, and usually between business and business, so B2B contracts. They'll normally become an issue, particularly when they are fairly large scale contracts, because obviously the more dollar value of the contract, the more important it is, if you are the vendor, to have any potential disputes litigated at home. Okay, and the best way to do that is to incorporate a choice of law clause and a choice of jurisdiction clause. BONYTHON tests are also something that you probably just need to tick off in your head before the exam. And choice of law clauses. Now, choice of law simply is an express term that you whack into your contract that stipulates the parties' agreement as to which country's law should determine any potential disputes or issues between the parties. If you don't do this expressly, it can make life difficult, and here is where the BONYTHON tests come in. It doesn't make it impossible, but it does make it difficult, and it certainly does protract any litigation that you might be involved in with the other party. So this is why I say put them in all contracts that you draft up, regardless of where the contract is intended to apply, even if it's a local contract. Certainly all the boilerplate contracts that we were using at Mallison's, which is now King & Wood, and at Clayton Utes, and the other firms that I worked at, they all had choice of law clauses in them, no matter what. The BONYTHON tests were set out by Lord Simons in BONYTHON and the Commonwealth. The first test, no real surprises there. Under the first test, the system of law by reference to which the contract was made is the one that's going to govern the contract. So easy peasy there. If you have expressly stipulated which country's law is going to govern the contract, that is the one that the courts will look to. The second BONYTHON test is the one that tends to be obviously used more because it's the one that applies where the area is a bit muddy and the parties have not stipulated which law is going to apply. And that BONYTHON test says, so you're going to choose the country's law which has the closest and most real connection to the contractual agreement between the parties. Okay, it's an objective analysis, and it's the analysis that results in the law itself selecting the proper law to govern the contract at issue between the parties. So you have the courts saying things like, well, where is the natural seat or centre of gravity of this contract? Is it in this country or is it in that country? And they look at things like, where are the parties' places of residence? Where is the place of business? Where is the place of contracting? Where do the parties have to perform? Things like that. And they'll go through this forensic analysis objectively to try and work out what the parties intended to be the governing law of the contract. So they're the BONYTHON tests, and that is the issue of choice of law. Very important because obviously, as I said, if you're going to get into a fight with another party and you've got cross-jurisdictional issues, you want to have the fight on your home ground. The other companion to the issue of choice of law clauses is the choice of jurisdiction, or sometimes called choice of forum clauses. And you normally have these two in the same section of your contract, usually towards the back somewhere. And all these clauses do is they specifically specify which courts, which tribunals, which arbitrators are going to settle disputes between the party. So you could potentially, by a choice of law clause, stipulate, for example, that US law is going to govern the contract, but you could actually have the courts of Australia being your choice of jurisdiction or choice of forum. Yeah, don't really know why you would do that. But anyway, I mean, it's a theoretical possibility. Generally speaking, what you'll see is this kind of thing. This contract will be interpreted under and governed by the laws of Australia, because you want to have the fight on your home ground. More particularly, you would be saying the laws of the state of Queensland in Australia. And then you'd have your jurisdiction clause. So the parties submit to thee, and you always want to make it exclusive jurisdiction, because then you can't get into an argument about whether or not it was open for one of the parties to select their home ground as the potential forum for the fight, okay? So the parties submit to the exclusive jurisdiction of the courts of the state of Queensland in Australia, and any courts that may hear appeals from those courts in respect of any proceedings in connection with this contract. So that is the issue of choice of law, choice of jurisdiction, or choice of forum clauses. You really want to make sure that you address that stuff up front, and like I said, it doesn't really matter whether or not you're going to have a local contract, not local contract. Have it in your boilerplate, have it in your template contract, then it's always there, you're not going to forget about it. The last thing I want to cover off today is probably the most important so far as consumers are concerned, and that is the issue of standard form contracts. Now, if you're a large multinational firm and you are contracting with millions of customers worldwide every day, how are you going to do that? You're not going to negotiate a fresh bargain every time, are you? You're going to be using standard forms. The good thing, I mean, standard forms are often talked about very pejoratively, but there are some obvious reasons why traders want to use these things, not the least of which being you physically couldn't manually negotiate a fresh bargain with every consumer nowadays, certainly not with online trading. No need to renegotiate terms every time, reduce transaction costs, obviously. If you have generated a standard form that ultimately becomes the industry standard, then that can increase confidence so far as both the industry and consumers are concerned in the nature of the contract, because it's been around for many years and used by a whole stack of different players in the industry. There I'm thinking of things like the standard licensing agreement that has been implemented by the Creative Commons people for copyright licensing. Certainly that's an almost de facto standard wherever you are going to be openly licensing your creative work. So there are some good things about standard form contracting. Where it becomes difficult is that obviously for large traders, Amazon and the likes of, there is a strong incentive to place the most favourable terms in those standard form contracts for your benefit, and to try and strip out as much of the consumer protections that are implemented in the various different jurisdictions, so that you can get away with as much stuff as possible. I mean, it just makes commercial sense, doesn't it? It's not terribly fair, but then again, neither is the marketplace. So to some extent, you've got to expect this stuff. What exactly is the size and shape of the market we're talking about in online contracting and consumer online contracting? Well, if you have a look at various different sources, I mean, you get different figures bandied about. But if you look at the e-marketer stuff, the overall e-commerce spend, they think, is around about nowadays $32.5 billion in 2017. They say that it's grown by about 22% in the last 4 years. They say there's an average per person spend of around $5,500 per year in online shopping. Then if you look at the Roy Morgan figures, have a look at that, 41.3 billion. They estimate the size of the Australian online shopping marketplace. Obviously, there's a very, very large audience for traders to reach in this fashion because of our comparatively good reach of internet access. About somewhere, you get different figures, somewhere between 85 and 80% of urban Australians have access to the internet. Of those users, around 65% prefer to buy online. Even like in terms of all you regional students that are quite geographically isolated, it can be quite important to conduct your shopping online because it's going to be the easiest way to get things done. A lot of the online shopping, so you can see there, 35% roughly of the online shopping is done by mobile phone users, and there's over 19 million of those. Social media is another way that online trading is conducted nowadays. You see adverts everywhere in Facebook, don't you? 12.1 million social media users in Australia. As you can see from those figures, it's not really surprising in that article that I got you to read by Malbon that they estimate now that the Asia Pacific market is in fact larger than the dollar-wise, larger than the US market or the EU market. So a formidable force to be reckoned with. Us guys down here in the Asia Pacific. So this is, I guess, the magnitude that I kind of want to paint a picture for you of where we're going and the need for consumer protections in terms of standard form contracting. Malbon says that around about 90% of the US online traders purport to exclude or exempt liability from consumer guarantees. Commentators opine that, oh, this is such a dirty tactic and these are strategies for taking advantage of consumers, or this whole process of taking advantage of standard terms turns the process of contracting on its head. Oh, look, I don't know, perhaps I'm just a jaded commercial lawyer, as I say sometimes, but I just think it's common sense practice if you're a savvy commercial operator. Economic wise, I mean, if you're talking about in economic principle, you've got the rational maximizer, haven't you? The trader is trying to maximise their returns, minimise their liability. This is the kind of conduct that is going on. It's not really a surprise, I don't think. The Melbourne article does go through, there's a couple of really outstanding examples where consumers have kind of rallied together and lobbied a particular trader to have their terms changed, one of which was the Dropbox example, and there was some talk for a while that Dropbox was actually purporting to get a worldwide royalty-free license to use all of its subscribers' content. And not surprisingly, the users, once the wind got out of all of this, the users banded together and lobbied Dropbox to change its terms. The Melbourne article goes into the very consumer-friendly replacement term that's now popped up as a result of this militating action by consumers. But that's more the exception than the rule, and generally speaking, large traders will kind of slip their terms by consumers, largely, I think, because we just tend not to read the standard T's and C's, do we? I mean, we're so eager to get that new dress or the new shoes or the new whatever widget that you just click on, commit to buy, and all of a sudden, there you go, you've contracted and you've accepted the seller's standard T's and C's. Like I said, not really surprising, but it is an issue. So, firstly, how do you go about getting the ACL guarantees on your side when you are contracting with an extraterritorial supplier? Well, if you're trying to enforce something like the quality guarantees or the sale by description guarantees or the unfair terms, under Section 5(1)(c), the ACL extends to extraterritorial conduct, but it's only if it fits within these fairly narrow parameters, okay? If the body is incorporated in Australia or it's carrying on business in Australia. Now, if that's the case, wow, you're home and host, but most internet traders that you purchase from will be from like China or the US or the UK, and you won't really be able to say that they are a body incorporated in Australia. It's a bit more of a grey area as to whether they're carrying on business in Australia, and the Valve case kind of touches on that. The other flip side is that if what you're trying to do is argue the consumer guarantees, you can try and argue that the conduct occurred in Australia, and for that purpose you're going to need to show that supply has at least been completed in Australia. This is a really super grey area of the law, and we haven't really had any definitive judicial authority on this as yet. There's a number of different ways you can turn around and look at the issue of supply. Does supply, is it started and finished? If you're buying from the US, is it started and finished, in the US when the supplier dispatches the goods? Who knows? Is supply a continuous process that's governed by a number of different jurisdictions? Does the supply process start, for example, in the US, and then does it, once it crosses international borders, does it have some kind of intermediate jurisdiction, and then does it finish off in Australia when there's been delivery to you as the consumer? What counts in that process? The supplier is most likely to argue, well, US law applies to us when we initiate that supply process, after that, it's kind of out of our hands. The text's view, Malbon's view, is that probably courts would give that argument short shrift, and they'd say it's this continuous process that ends up in Australia. But like I said, there's nothing really definitive here for us to go by. So the issue of trying to apply the consumer guarantees to overseas suppliers is a tricky one when you're trying to argue that notion of supply being here. So there's the two main ways that you might try and get an overseas supplier subject to the ACL. The Valve case is a very interesting case. It's still being fought out as we speak. But what happened was there was a very large US software company, gaming company, based in Washington State in the US, and they operate this Steam online gaming platform where you can go there and you can download games that you want. Has a huge revenue, about $3 billion, 2.2 million Australian users, and they do their downloading of the games and they go away and they play them. Okay. The problem here was that apparently the quality of these games was not necessarily fabulous, according to some consumers. And the ACCC stepped in. Now, this is where it's interesting because these kinds of cases are going to be so difficult for individual consumers to run because they're just so darn expensive. And usually your loss is going to be reasonably small in dollar terms, might be fairly large in frustration terms, but fairly small in dollar terms. And most consumers are just likely to go, oh, well, cut it loose. I just won't visit that Steam site again and try and download any more games. The ACCC was obviously alerted by a number of different consumers, and so it took the step of actually entering the fight here on behalf of the Australian consumers. And it said that Steam had, Valve via Steam, had made misleading or deceptive claims to consumers. And where were those claims? In the standard forms, okay, in the standard terms, the refund policy. They said that consumers were not entitled to a refund in any circumstances, so big red flag there. They excluded and purported to restrict the various guarantees that were applicable. So Justice Edelman held that the fact that those standard T's and C's were put up onto the Steam website and were received by Australian consumers, that was sufficient to constitute conduct occurring in Australia. Note that's a bit different to the issue of whether supply was in Australia, as we just discussed previously, because supply is a bit more of a tricky and multifaceted issue. But nevertheless, in terms of Section 18, misleading or deceptive conduct, this was in fact conduct that occurred in Australia. Interestingly, Edelman also held that the fact that even though Valve and Steam were operating from Washington State, they were held to be carrying on business in Australia. Now, that's a fairly big stretch, and not surprisingly, that issue is on appeal. They were held guilty of misleading or deceptive conduct, and $3 million worth of penalties were applied. As I said, this is all still going on. It doesn't really touch on that supply issue that we looked at just previously. Valve's position, not surprisingly, in this litigation was that it was just not subject to Australian law, and you can understand that this stuff is all such a grey area. You're going to take every point you can, aren't you? And that's exactly what Valve certainly did through its litigators. And Justice Edelman, you could kind of sense that he's getting rather frustrated at times, and he says that Valve contested liability on almost every imaginable point. A little bit ticked off, I think. But like I said, understandable. If I was Valve's lawyer, that's exactly what I'd be instructing our counsel to do. What happened, apart from the $3 million worth of penalties, was that you got these rather nice little ragtag bunch of ancillary orders made, and these orders marry up with the ones that we were discussing in the ACL remedies video for the last topic. So we have Valve having to publish information on its website about Australian consumer guarantees for 12 months. They have to initiate a consumer compliance program. So it's not sufficient that they just put stuff up on their website. They actually have to go through their business practices and establish this compliance program respecting consumer guarantees, which is rather interesting. And it's not allowed, so there's effectively a gag order. It's not to make similar representations to Australian consumers for a period of 3 years. Like I said, this is all still going on, fresh. If you Google it, I'm sure you'll find out some information. Specifically, the 2 points that are on appeal are that the subscriber agreements and refund policy were misleading, so the finding of the actual breach of Section 18, more particularly for our international aspect that we're looking at today, was that Valve had engaging conduct in Australia simply by virtue of its internet website being available here, and that it was carrying on business in Australia. The ACCC has cross-appealed. I suspect that the ACCC has deeper pockets, so it can fight to the bitter end, but again, we'll have to keep posted on that. It's a great piece of litigation, so far as we're concerned, this week to highlight the issue of cross-jurisdictional trading. But it's also rather a sad story, because whilst the ACL guarantees are there, and this kind of litigation theoretically could be taken by a consumer, they just wouldn't have the deep pockets. So although the ACCC might ultimately have some rather useful precedents set for us, even if there is clear authority on the application of the ACL to overseas suppliers, I'm not sure whether the average Joe would have the time or the money or the mental headspace to run a serious piece of litigation against a large overseas online retailer. So that's the Valve case. The next hurdle that you face in terms of contracting with overseas suppliers and particularly large internet retailers is that they're always going to choose the home ground advantage for disputes. So they're going to have a choice of law clause and a choice of forum clause that stipulates their home country in order to give them the best protection. What about sections 64 and 67 of the ACL? So these are the ones that say you can't exclude consumer guarantees. If you do so, that particular clause is going to be void. And 67 is the one that says, well, where there's a conflict here and there's a choice of law clause, the ACL is going to continue to apply, notwithstanding that the other party has stipulated, usually the other party, the online supplier, has stipulated that their home ground law is going to apply. Well, where does that really leave us? I guess we've got to ask the big so what kind of question. Well, I guess the answer is fairly dismal, actually. The ACL is going to be very hard to get a decent hearing if you're trying to argue it just as a private matter, rather than in the Valve case having the ACCC step in with its collective might and sue in Australia for conduct that it's saying that the overseas retailer engaged in Australia. If you're left with that private option, litigation between the parties, the online overseas retailer will have stipulated their choice of law, choice of forum clauses as their home ground. So for example, as I've got here, if their home ground is the US, then the US law will apply to that particular contract generally, and usually you'll have US forums being stipulated as the appropriate fora for resolution of contract disputes. So that means that you've really got to ask the US fora. Usually arbitration is specified as the most convenient means of resolving disputes for online retailers. You'll be asking the US arbitrator to apply Australian law against its own US citizen that's apparently done the naughty stuff. Now, as you can imagine, this is a very political process, and the US arbitrator is probably not going to like the idea of having this incursion of Australian law to somehow try and restrict the things that its own citizens can engage in. In particular, the US allows trading operators a fair bit of leeway in terms of what they can exclude. They can opt out of or restrict consumer guarantees. They can limit them, to a certain stipulated period of time, which is not the case in Australia. So an arbitrator over there is going to find it pretty much of a hard ask to restrict their citizens' rights in the aid of applying our extraterritorial reach of our ACL. As Melbourne says, it's going to involve fairly complex legal proceedings in multiple jurisdictions to try and get this stuff to happen, and in the end it's really probably not worth it. So whilst the ACL may purport to ride over the top of a choice of law clause in your contract, the realities of actually being successful in getting the ACL applied by an overseas forum to any particular contract dispute is fairly slim to none. Okay, unless you've got extraordinarily deep pockets, of course. So they're the main takeaway points of international contracting so far as Contract B is concerned, and that is topic 11. And like I always say, guys, if you have any problems or queries, just shoot me an email, post up something on Facebook and we can clear them up. Otherwise, I look forward to seeing you in a Zoom sometime soon and start sorting up for your exam, which is coming up very soon. Anyway, thanks, guys. Bye.